Good afternoon and good morning, everyone, and welcome to Thrive in 2025, a monthly webinar series brought to you by ARCpoint Labs, where we empower business leaders to create compliant, high-performing, safe, and healthy workplaces that thrive. My name is Ryan West, your host and Thrive specialist, and proud to be sharing the virtual floor today with Shelley Jackson, attorney and partner at Krieg DeVault LLP, a premier business-focused law firm serving clients throughout the Midwest and across the U.S. Before I introduce Shelley and she takes the virtual stage, I have 5 very brief announcements. First, this webinar is being recorded. For those interested in an immediate encore presentation, or if your boss or teammate wasn't able to attend today but wanted to, or if you think they should have attended after you hear Shelley speak, the recording will be posted to ARCpoint's website by tomorrow morning. Second, ARCpoint is proud to be a recertification provider with HRCI and SHRM. So if you are a credentialed HR professional, you'll receive 1 recertification credit and 1 professional development credit upon completion. The IDs for each will be posted in the chat at the end of today's webinar, so keep an eye on the chat. And they'll also be listed on your certificate of attendance, which will be emailed to all attendees end of day next Monday, along with the recording link and also a PDF copy of today's slide deck. But, and I emphasize this, you must attend the entire webinar today to receive the certificate. Again, you must attend the entire webinar from start to finish to receive a certificate of attendance. Next announcement, our upcoming webinar on Thursday, May 22nd, and every odd month for the remainder of 2025, I will be presenting the 2-hour virtual training Identifying and Responding to Workplace Impairment, a reasonable suspicion training for supervisors. This virtual training is aligned with 49 CFR, Part 3D2603, training for supervisors. So if you need this 60/60 training or are simply looking for a refresher on this topic, you will receive a certificate of completion for attending. And it's also accredited for 2 CEs through SHRM and through HRCI. There is a caveat, however. Unlike today's training, which is publicized, you need to reach out to your local ARCpoint Labs provider if you're interested in learning more or registering for the May 22nd training. Fourth, we invite you to spend just a moment of your time after today's webinar to complete the post-webinar survey or post-training survey. A link will be posted in the chat towards the end of the hour. Simply click on the link, follow the prompts, and give us your honest feedback. Like all ARCpoint surveys, it's super quick, it's easy, and it's completely anonymous. And your feedback helps to ensure that we continue to select timely topics and highly qualified speakers like Ms. Jackson. And of course, it helps us to ensure that these webinars are worth every second of your valuable time. Which leads us to our 5th and final announcement. In this virtual, fast-paced world, I firmly believe that time is our most precious commodity and attention is our most precious currency. We want to thank you for giving us both your time and your attention. And to make the most of your time, you're all encouraged to engage with our speaker and with each other using the chat and the Q&A. If you have a question, please use the Q&A function so I don't lose it, and use the chat for everything else. We have an attorney presenting, and you know what that means. A lot of questions. I don't want to miss them. So again, if you have a question, please use the Q&A. And then if you're just engaging with each other or you're answering a question pitched by Shelley or myself, then you can use the chat function. And on that note, I am so pleased to introduce our presenter today, the highly experienced, highly accomplished, and highly respected attorney, Shelley M. Jackson. Shelley is a partner at Krieg DeVault LLP and chairs the firm's labor and employment practice and also the Artificial Intelligence Task Force. Her practice includes employment law, professional ethics and compliance, and data privacy law, with a strong focus on serving healthcare and nonprofit clients. Now, I had the pleasure of sitting through a presentation of Shelley's a couple years ago, and it was part of an all-day conference on mental health in the workplace. And there were a lot of really good topics that day and a lot of good presenters, but she was the standout shining star. And as I thought, our customers would love this presentation, love this content, as would the entire ARCpoint team. And So now here we are. So Shelley, a very warm welcome to you. Thank you so much for being here, and the floor is yours.
Fantastic. Thank you so much for welcoming me, Ryan, to this presentation today. I'm having just a moment of a technical issue getting my slide deck ready to go. So I'm going to get that started here in just a moment.
Not a problem.
I want to make sure I am sharing the correct slide deck. So give me just a second.
You got it. I'll engage with our attendees.
Sorry
Hello,
about
Jennifer.
that.
Welcome. Carmel, welcome.
Let's see.
Donna,
Here we go.
welcome.
Here we go. So yes, I am accomplished at many things, but apparently starting my slide deck in a successful manner is a little bit of a challenge here.
You're
so
not alone, Shelley.
Here we go. All right.
I'll
Got
let you know when I
that.
see it.
Okay, let's see here.
Hello from California. Lindsay, welcome. Courtney, welcome from Alabama. Harry, Michigan, welcome. My wife's family has a nice plot of land up on the finger near Northport, just north of Traverse City. Wonderful place. There we go, Shelley. You're good to go. All yours.
Excellent. Well, thank you very much for that indulgence as I was figuring out the screen sharing scenario here. And let's get over to the correct slide. I'm not sure what's happened to my controls here, so apologies. Let's see. Okay, here we go. We're rolling. Okay, so here's my first slide, and I'm going to dive right in. As I mentioned, and as Ryan mentioned, we had a chance to meet over some presentation work that I was doing in the space that I'm going to be discussing today, some community-based work with employers to talk about the issue of mental health and substance use disorder accommodations in the workplace. I am an attorney at the law firm of Krieg DeVault. I chair our labor and employment practice group. So we spend a lot of time as a team addressing some of these issues. So I'm very happy to be with you today. I look forward to this conversation. I think it's a critical conversation for organizations to be having. And I will say in particular, one of the things I really enjoy about this opportunity to present with ARCpoint is that there are other pieces of complementary content that are delivered to you through this platform that I think pair together nicely. Ryan and I were chatting about that before we started our presentation today, that there's a lot of great overlapping content here that will help you find various ways to consider options to accommodate workers, compliance issues, and all of the different training and programming opportunities that you might have for your team. So a little about me. I concentrate my practice, obviously, in the area of labor and employment, because that is the area that I lead. I also am a healthcare attorney in the sense that I do some healthcare compliance work as well. I will say that this particular topic intersects very closely with employers who are looking at the healthcare component, whether they are healthcare providers themselves or whether they have employees who are interacting with the healthcare industry. So it's a nice crossover in that regard. Our labor and employment practice has 14 attorneys dedicated to various types of labor and employment issues. All of these issues are things that come up on a day-to-day basis with employers. So regardless of what size employer you are, where you are throughout the country, we are frequently handling some of the challenges that you see in your day-to-day job duties. So this is definitely very near and dear to my heart to engage with you today, to hear the questions you have, to hear feedback as we discuss today. I do want to make sure that I'm clear in my disclaimer, so I will cover quite a bit of compliance-related material today. But it's important to remember that while I am an attorney, I am not your individual attorney, or at least not that I know for this purpose. So from that perspective, just make sure when you have these particular scenarios, keep in mind they're very fact intensive, and make sure you're reaching out, whether that's someone in your organization, whether that's outside counsel that you work with. You're certainly always welcome to reach out to me if you have a particular question and would like to discuss further, but make sure that you seek advice for your particular situation. So let's talk a little bit about what our discussion today is going to look like. We're going to start by setting the scene, and I'll tell you a little bit about how these slides developed as I was putting together this presentation, because these slides were not actually originally part of the presentation. Then we're going to walk through the basics of the ADA, the Americans with Disabilities Act. Now, depending on your role with your organization, this may be old hat to you. This may be something that you deal with on a day-to-day basis already, and so it may feel a little bit like review. But what I have found is even people who are interacting in a frequent manner with the Americans with Disabilities Act find it helpful to dive in and think about ADA accommodation obligations and other provisions from this particular perspective. So I hope you will find something useful and helpful, even if you're already familiar with the area. Then we're going to talk about other laws at the federal level which interact with the ADA. In other words, some of the things that are happening in pursuing an accommodation obligation or thinking about working with employees who have mental health or substance use disorder challenges, some of those things may trigger other laws as well. I do want to note in terms of scoping, because this is a national audience, you may be in a variety of locations that may actually have state or local laws that may come into play here. You may be in particular work environments that have additional provisions relating to addressing these issues. So I definitely want to highlight that this is a broad overview from a federal perspective. It's designed to be very broad. It's in that sense, and it's not tailored to any specific state or locality, but there are also considerations that we can think about for those contexts as well. And the nice thing about the federal perspective in this particular area is that it offers a very good blueprint in many scenarios to give you a good compliance framework to work off of at the state and local level. And then we'll go over some general best practices, things that I've seen in working with clients that can help navigate these issues as well as possible. And kind of thinking about it from a risk management perspective. And then we'll have a little time at the end for you to share questions that you might have that you can be placing into the chat as we're having our conversation today. So again, going back to my introductory slides here, these slides were not originally part of my presentation, but I thought the information in them was compelling enough that I wanted to share it as sort of a context setter. So as I prepared this original concept and looking through the idea of compliance with respect to mental health and substance use disorder issues, I knew as a practitioner that I was seeing these issues crop up pretty regularly. Just by virtue of the type of practice that I have and the way that I'm working on a day-to-day basis to counsel clients, I was just seeing it quite a bit. How do we navigate this? What are some of the questions? And so it made me curious to know, like, what is the prevalence when we're talking about looking at mental illness in our society, looking at substance use disorders in our society? Really, what's the prevalence here? Is this something theoretical that people may run into? Or is it something that is more ubiquitous, a part of who we are? And the statistics, I think, are compelling. These are a couple of years old, but are generally some of the most up-to-date information available. So thinking about mental illness as a general concept, almost 16 million of us are living with some type of mental illness. Now, I want to be clear, not all forms and severity of mental illness would necessarily trigger Americans with Disabilities Act accommodation obligations. But thinking of mental illness as a broad sense, this tells us that a substantial portion of our population, 1 in 5, is navigating some type of mental health challenge at any given time. Of that, we dial down a little bit to 14.1 million adults have what we would classify as a serious mental illness. So when I read those statistics, my immediate question was, what qualifies as a serious mental illness? And that means a mental, behavioral, or emotional disorder resulting in serious functional impairment that substantially interferes with or limits one or more major life activities. So I want you to think, for those of you who are familiar with ADA, that language should ring in your ears because it's a very close track to the type of standard that needs to be shown in order to trigger ADA coverage obligations. And another statistic, again, wasn't originally part of what I intended to include, but I thought it was fascinating as well. When we think about our adolescents, our teenagers, we're looking at almost half of them either have or have had a mental disorder of some sort. Again, that's that broader bucket. It's not specifically saying a serious mental illness, but, such that ADA accommodation would be implicated. But I think it really just teaches us who we are, right? That this is something that if we as employers, if employers get better about addressing these issues, it is going to benefit everyone within the workplace. Because when we talk about these things, the chances are very good, almost 100%, that we either know someone, we love someone, we work with someone, or we are someone who has some sort of mental health challenge. So think about it from that perspective. I absolutely don't want to have this conversation in a sense of, oh, you may encounter this issue or you might interact with an employee at some point. We know for a fact that all employers at some point will encounter this. So that takes me to the next slide, which is the same thing. Thinking about substance use disorders. What is the prevalence in our society? We know it's a lot. We know that particular communities may be hit very hard by substance use disorder challenges. Here in Indiana, we have had several communities that have been rocked by addiction issues. And so employers are navigating this on a regular basis. So thinking about the statistics, again, 46.3 million people, which is 16.5% of the US population, met the criteria to have a substance use disorder. And that's divided out as kind of half and half almost, alcohol use disorder and drug use disorder. That distinction will become important as we continue our discussion because the legal obligations surrounding those two types of substance use considerations are different. 9.2 million people age 12 or older misused opioids in the past year. Again, that speaks to some of the addiction issues that have devastated communities and have become very much a part of the communities navigating what their future looks like. And then I also want to highlight this last statistic. This may be the most compelling statistic that I saw in my research. 94% of people 12 and older with a substance use disorder did not receive any treatment. And the reason that people don't receive treatment said that they felt like they did not need treatment. And that statistic, I believe, isn't just that statistic. I think it underlies this issue of that there can be stigma with seeking help. It can feel disruptive to day-to-day life. People may think, how do I get help when I have to keep my household functioning? I've got to get to work every day. I have children to take care of. I have a family to support. All of these other considerations that get in the way of seeking assistance. And then I think there's also a piece of what will people think? What will people think about me if I seek treatment in this way? So with that as context, again, extra information, but super helpful to navigate and understand the context that we should view these topics from. Let's walk through the ADA, just the basics. Let's dive right in. So the Americans with Disabilities Act is a law that is a federal law. It was passed in 1990. So for any of you who are anywhere near my age range, this is a particularly poignant statistic because this is in my lifetime. This isn't, it did not it did not exist, it's within many of our lifetimes. So this is actually a fairly new law when it comes to the different equal employment opportunity laws. We call them EEO laws. So it is one of the newer ones. Title I of ADA is what we're going to focus on today because it is focused on employment-related issues. But it also protects individuals in a lot of different scenarios: employment, transportation, public accommodations, access to government programs and services. So it's what we would call an omnibus disability accommodation law or disability rights law. But we're really kind of slicing it down to what we see in the employment context today. If you are an employer who has more than 15 employees, certain types of government agencies, certain types of labor organizations, this is a broadly applying law that likely will apply to your organization. And I will add kind of the state local focus, even if you, let's say you have 10 employees and you're not subject to ADA. In Indiana, even employers who have 10 employees and aren't subject to ADA, there is a state level law with very similar protections that will step in and provide that coverage at the state level, even if the employer isn't triggering federal coverage. So that's something important to keep in mind with that state local perspective. Even if you see this and think, why am I on this webinar? This doesn't apply to me. It really is going to offer good general information, and compliance best practices apply across the board. Let's see. It's enforced through the Equal Employment Opportunity Commission. The EEOC has been actually in the news quite a bit, so I'll have some commentary about that as we go through our discussion today. And then there are state agencies that step in and collaborate with the EEOC to enforce those laws. So what really is the ADA? What does it do? At its most basic level, it protects against discrimination on the basis of disability and also retaliation. So it's not just a protection against the discriminatory animus, for example. I don't want to work with someone who has a particular disability, or that bias or stigma that we talked about that sometimes people are worried about, and with good reason, because I think there is a strong history of bias or stigma that can come with both mental health disorders and substance use disorders. It's not just active employees. When someone is applying for a job, that also triggers coverage. It also, so in addition to that protection, it also is powerful in that it creates an obligation to provide what we call a reasonable accommodation. We'll dive into that in a little bit more detail here shortly. But again, it deals with the reasonable accommodation obligation. And then it requires employers and employees. There's obligations on both sides to engage in what we call an interactive process. And that means they've got to work together to find out what the best reasonable accommodation is. Is there a reasonable accommodation? And if so, what is that accommodation? And then it also establishes strict employer confidentiality obligations that we'll talk about in a little bit. But essentially, sometimes you will hear people say that HIPAA applies to accommodations, disability accommodations in the workplace, with a very, very tiny caveat. If an employer is a self-insured employer, HIPAA does not actually apply to employment-related medical information, but ADA steps in and it provides protections that are in some ways even stronger than the protections that are provided by HIPAA. The other compliance note, added this after I created this slide. Thinking about amendments and changes that occur on the way, understand that your compliance landscape and your risk management landscape will change over time. This is just one example. In June of 2023, we had the Pregnant Workers Fairness Act go into effect, and that created specific obligations that require accommodation for physical or mental conditions related to pregnancy, childbirth, and related medical conditions. So the purpose of leaving that there is that if you are very familiar with the ADA, one of the things that you will know is that the ADA, if you are a person who is pregnant, an individual who is experiencing pregnancy may not necessarily have the conditions that are sufficient to trigger disability-related accommodations. In other words, pregnancy in and of itself, a woman being pregnant in and of itself, does not itself constitute a disability. And so there was a gap for a while. Now, the Pregnant Worker Fairness Act drops into that gap and actually creates an accommodation obligation for pregnancy as well. We won't dive into that very far, but it's just something to keep in mind as you're thinking about your accommodation obligations. Just make sure you know that full compliance landscape. So let's talk about it. What is it? What exactly is covered under the ADA? First, we're looking at physical or mental impairments. That means that if you have a mental health impairment that rises to the level of a disability, that is in fact sufficient. It doesn't have to have a physical manifestation. And the test is whether it substantially limits one or more major life activities. Protection also applies if you have a record of an impairment or if you are regarded as having an impairment. What that means is that the ADA doesn't just apply to individuals who have a disability at a particular time. It is a broader scope of protection that applies to people in a variety of scenarios. Examples of major life activities, oops, sorry about that, went a little bit ahead, would be sleeping, eating, working, walking, talking. So there's an entire list. It's a non-exclusive list. And I will tell you that it is something that is interpreted by court. So that can sometimes vary from place to place in terms of what's determined to be a major life activity. But you think about what is it that people do in a day? It's almost an unfettered list of different activities that can qualify. Not everything is a major life activity, and that is something that's frequently tested by the courts, but some things and many things can be, in fact, a major life activity. Okay. Thinking about the basics of ADA compliance and moving on now to what does an employer have to do under the ADA? Employers must, upon request, make a reasonable accommodation to a known disability of a qualified applicant or employee if it does not impose an undue hardship on the employer. What that means is that the employer has a standard that it can use to review a particular request for accommodation. And I think on my prior slide here, I also wanted to note that it requires someone to be a qualified individual with a disability. So there's both the requirement to show that you have a disability, to establish that you fit under the definition of having a disability, but also that you're qualified to do the job, that you can perform the essential functions of the job in the context of with or without a reasonable accommodation. So that gives you context for this particular comment here. There's no language, there's no magic language that an employee has to use. And in fact, if an employer becomes aware, even if the employee hasn't said something, that an accommodation may be necessary, they have an obligation to follow up on that and engage in the interactive process. So part of this is talking about, and this is actually a fairly regular conversation, what constitutes an undue hardship? In this particular context, an undue hardship is a defined term, an action requiring significant difficulty or expense when considered in light of factors such as the employer's size, financial resources, and the nature and structure of its operations. I do want to caution employers that this can be an area where there can sometimes be some compliance challenges, because there can be a perception that a particular requested accommodation is difficult, or it will incur some financial resources. It will require some financial resources. And there can be almost a presumptive tendency to think that the undue hardship standard is met. This is a pretty high standard. So it's really important to consider what constitutes an undue hardship under the circumstances, and making sure that you understand whether or not your scenario fits that standard. The other thing that would not prohibit, but would not make it required for an employer to impose a reasonable accommodation is if there would be a direct threat posed by that accommodation. So in other words, the accommodation itself could otherwise be reasonable, but because of the way that the accommodation would be imposed, it could pose a hard direct threat to others within the workplace. We saw this crop up a lot during the COVID pandemic about, for example, if there was a small workspace where people, where a requested reasonable accommodation was, I don't want to mask according to my employer's policy. Now, there's been lots of discussion since this time that CDC standards have changed, but at that particular time, the CDC standards did have a specific masking regimen to use throughout the pandemic. And so if someone said, I can't wear a mask because of this, and I'm requesting that as a reasonable accommodation, a direct threat analysis would have to be undertaken to make sure that other employees would not be exposed to an unsafe work environment. Okay, looking at accommodations for the ADA, you think about individuals with mental health conditions, they will be covered under the ADA. Individuals with an alcohol addiction, which rises to the level of a disability, will be covered under ADA. And then here's the distinction. Remember, I said at the beginning of our conversation, I said that alcohol and substances are treated differently. So alcohol and drugs would be treated differently. And here it is. So individuals who are in recovery from or are regarded as having an addiction to illegal drugs are covered under the ADA. Individuals who are actively involved in illegal drug use are not covered under the ADA. So that's different than someone who is actively consuming alcohol. And I don't mean actively consuming alcohol at work. I mean actively consuming alcohol as in they are not in recovery or remission from their addiction. So very frequent question. Okay, so how do we accommodate? What are some of the different accommodations that might be a reasonable accommodation here? Okay, so you will see that this is a list that we've compiled actually from different areas of guidance that are available. One of the things I like about this presentation, and I'm glad you're going to receive a PDF version of it, is we've embedded a lot of really great links that you can go to that will have some different information available that will help with exploring these accommodation obligations. So thinking about some of the different examples of accommodations that could be done, thinking about work schedules. And this is this can be a challenging question or issue. One of the pieces of feedback that I have received in the past, and it's not infrequent that I hear this feedback, is that's really hard to implement, because if this person gets to come in 2 hours late on Thursdays, how does that play with the rest of the workforce? And the answer is, even if someone else does not particularly like or appreciate that someone's schedule gets to be adjusted or needs to be adjusted as a reasonable accommodation, it doesn't excuse the reasonable accommodation. In other words, another coworker being displeased or wanting to have the same adjustment to work schedule, absent some reasonable accommodation need on their part, doesn't resolve or eliminate the need to accommodate. So part of it is navigating. Any of you who work in an HR context, or who are leaders within your organization, you know that you frequently feel that uncomfortable space where you have information that you're not allowed to share. You have to take a particular action that may not be popular, but you have an obligation to do so. So you have to do the right thing, even if you get some pushback. And so that is one of those areas, is implementing accommodations may not always be popular. It may not always be easy to do, but it is really important to maintain confidentiality and still work through those things. Quiet office workspaces, changing in supervisory methods. This is a tough one too, because there can be, depending on the work environment, there can be a real dedication. Like, we all like the way that we work, right? Like we think our approach is the best approach. I prefer to give this kind of feedback rather than that kind of feedback. But from a supervisory perspective, if there is a reasonable accommodation request, then the organization would need to think about, is there a different way to deliver this feedback? So keep that in mind too, that even just the way a supervisor is interacting with employees can be an accommodation issue. Remote work, changes in communication protocols. Are you emailing instead of texting, instead of this or instead of that? Those are all different accommodations that can be reasonable. I will not spend much time talking about service animals or emotional support animals, except to say there are some really good resources available. I see one of our links down here that you can access and think about how to navigate the service animal or emotional support animal in the workplace issue. I do want to highlight, though, service animals are typically not specifically called out, and so there can be a perception that not service animal, emotional support animals are not called out in federal law. And so there can be an assumption that an emotional support animal from an employment context can never be a reasonable accommodation. I would urge you to look deeper into that, because that is not always the case. There are cases where even an emotional support animal can be considered a reasonable accommodation. Now, there are other contexts where an emotional support animal is not permitted, or there's no legal protection for it. But in this particular context, when we're looking at the employment relationship, you should not discount a request for accommodation simply because it involves an emotional support animal rather than a service animal. Again, it's the same inquiry, interactive process, decide whether there are different accommodations that may be reasonable. Another very common question that is worth a little bit of a deeper dive as we talk here is drug and alcohol testing. So tests for alcohol are considered medical exams under ADA. They have to be job related, consistent with business necessity. or based upon reasonable suspicion. And I think I heard Ryan talking about the fact that you're going to dive into the reasonable suspicion standard in an upcoming training. So I think from that perspective, it's really important to understand those distinctions and make sure that an organization approaches it in that way. Tests for illegal drugs are not in and of themselves medical exams under the ADA. And I have to be honest, I cringe when I think about that, because the information you gain from a drug test, even if the drug test itself is not considered a medical exam, is medical information about an employee, and so should be treated with the same level of care, should be kept separate from the employee file, should be kept as an employee medical employee medical file, should be treated as such, even though there is technically by law a difference between drug and alcohol testing. They should still generally be treated with the utmost of privacy and confidentiality under ADA. Thinking about medical inquiries and examinations, when those happen, is very important. Before an offer of employment is made, now we're in the applicant space, there can be questions about an applicant's ability to perform specific job functions. You could, again, in theory, because a test for illegal drugs is not technically a medical test, you can't inquire about a disability or require a medical exam, including an alcohol test. So there's a little bit of a disconnect there. For practical purposes, it's typically not a good idea to do pre-offer drug testing, even though it's not unlawful, just because you have to really build up a good program and make sure that it's fully compliant. Doesn't mean you can't do it in some instances, but for most instances, the testing and the exam, or the testing along with the exam, need to happen at post-offer. So when you get to post-offer, you can ask health-related questions, you can require drug tests and medical exam, as long as you're doing so in a consistent manner for all applicants in a job category. So you can't screen someone out and say, I think I'm going to test this person, but not that person, because that would be an impermissible and unlawful way to decide who is tested within a particular category of job. But if you're testing everyone within a category of job, that would be a permissible way to do it. Performance-based inquiries are the way to go here, because really, to be honest, people feel like sometimes you get questions that say, I think so-and-so may have a drug or alcohol problem. But really, as an employer, typically what you're asking about is performance-related issues. Someone is behaving in a way that is inconsistent with the way they typically behave. Someone is arriving late for work, leaving early from work, missing work, things that are unusual for that person. It's really the performance issues that are driving the concern, even if it feels like there's a suspicion about what might be causing those performance issues. So I think one of the things that you can do is focus really on the performance issues themselves rather than the potential causes. We talked about this already, and so I won't spend too much time here, but keep in mind that there are strict confidentiality provisions for ADA protected information. Now we'll do like a flyover of some of these other federal laws that come into play. So those are the basics of the ADA. It kind of sets the framework. There are a lot of things for an employer to think about. And when you're thinking about accommodations specific to mental illness or drug and alcohol substance use disorders, I think there are a lot of things to think about. Now let's think about these other federal laws that come into play. Probably the most significant one that would impact how an employer responds to this is the Drug-Free Workplace Act of 1988. Any of you who have a drug-free workplace, there's two ways that you get into having a drug-free workplace. And when I say drug-free workplace, that's a term of art that refers to this specific statute. And then maybe sometimes there are state statutes as well. But it is something that can be required for federal contractors and federal grantees. So in some sense, they have to. But then other organizations may not be subject to this by statute, but may choose to comply, or they may agree by contract to comply based on another organization's requirements. So all that to say is it can be a fairly complicated analysis as to whether you are required as an employer to implement a drug-free workplace. And so there is a variety of ways that can come into play. So again, drug-free workplace, remember I said it's a term of art. It's not a generic term. Here's what it means. This is actually taken from the federal law, and you can look through and review the specific elements of that when you have a chance on the PDF that will circulate. But there are notice requirements. You have to report violations as required. You have to notify employees that you're going to do that. So there are a host of things that are required. Note that it doesn't require immediate no tolerance policies with respect to drug use in the workplace or drug or alcohol issues within the workplace. What it requires is a discipline program that either pushes someone to a drug abuse assistance or rehabilitation program or does result in disciplinary action that could include termination. Then there's the Family Medical Leave Act. This is a federal law that only applies to larger employees, so 50 or more employees, as well as certain public entities and educational agencies. And also there are some compliance standards that have to be met or eligibility standards that have to be met. But it's basically, it's an unpaid leave entitlement that certain employees may have in order for their serious health condition or the serious health condition of a family member. And there are some other ways that FMLA can be invoked, but for purposes of our discussion, it can authorize or be a protected leave that an employee can use to, for example, enter into a rehabilitation program. OSHA, Occupational Safety and Health Act. This is one of the standards that actually hits both federal and state, because there is the federal OSHA standards, which is what you see cited here. But then each state has the option of either taking over some part of the OSHA implementation or allowing federal OSHA to come in. For example, in Indiana, we have IOSHA, which is the state implementation of the federal OSHA standard, and it has to meet or exceed the federal OSHA standard in every respect. And then there are some areas where Indiana has taken and has decided to regulate its own create its own standards that are, again, have to be equal to or above the standards for federal. All right, so this has been a big flyover of some really important federal laws. I do want to emphasize these laws are complicated, fact intensive. So doing an hour discussion on this, or our 45 minutes of active content, is not going to give them justice as it relates to specific scenarios. But what I thought would be helpful here is let's give you some bang for your buck and think about, okay, as a practical matter, how can we go back to our workplace and think about how we are interacting with employees? A statistic that is not in this presentation slide deck, but it's something that I would compel you and suggest that you follow up on, is when you look at individuals who've had an opportunity to be supported by their employer and maybe be given a second chance in some scenarios, they actually perform really well over time. In other words, if the concern is, I'm worried about performance, or I'm worried about risk management, there are ways to manage risk. There are opportunities to implement state and federal statutes and other programs, grant programs that can come into play. Indiana, for example, has a particular grant program that allows employers to avoid civil liability in connection with retaining an individual with a known substance use disorder, as long as they participate in the established statutory standards. So it allows employers to have some protections in that space. So I want to encourage you to think creatively about different ways that it doesn't have to be an all or nothing scenario or zero tolerance. It doesn't mean that zero tolerance isn't an option. If someone is, for example, inebriated on the job, an employer has the right to enact whatever discipline is appropriate there, and in some cases may have to, depending on what the scenario is. But there are certain circumstances that can offer some additional options. All right, so diligence, just know your compliance landscape and your organizational priorities. There is this sense of, and I always tell audiences that I speak to, if your standard is like, what is the minimum that I can do and stay compliant with the law that I have, I think it's a tough approach, right? Because as an employer, you're wanting to find people who are great candidates. They're good at what they do. They're going to thrive over time. And what we know about employees over time, think about those statistics. a lot of your employees may be great employees who go through a tough patch. And so I think it's as an employer thinking, yes, what do we need to do to comply legally? But also, how can we support our employees in a manner that doesn't increase our legal risk substantially, but also maybe goes a little beyond what is required by the very basics of the law. So that's the organizational priorities piece. Empowering your leaders and your team, make sure they know the law. You know, I get a lot of feedback and I work with clients sometimes on issues where managers just don't understand what their obligations are. They don't, they don't intend to engage in behavior that could be seen as non-compliant, but they're just trying to navigate an area that they don't really understand. Walk the walk. You know, in a structured organization where there's different levels within the organization, make sure that your leadership is also held to account for the things that you say is important as an organization. That means if you say that people need to participate in training and need to know how to navigate mental health or substance use disorder issues, or even just accommodation issues, make sure that the leadership is invested in that, because frankly, they're the ones that will be implementing a lot of these things. Keeping an open mind. This speaks to the stigma issue. This topic tends to be stigma driven sometimes. People just, they may feel embarrassed that they're struggling with it. People may be embarrassed to ask. Again, when you're in a supervisory role, if this is, you know, if you're in an employer role, you have to be careful about what you ask and how. But you would be surprised if employers ask good questions, legal questions, but ask good questions and engage with employees. A lot of times employees will give information that can help that interactive process. And then as I wrap up, this is my last page of best practices, being intentional. Don't wait until a problem happens. Thinking about it as things are happening, update policies and procedures periodically. When you become aware of new obligations. I mentioned at the very beginning of my presentation that we're in a very changing landscape right now, and that includes with respect to accommodations for disabilities. You do have to keep in mind that we've had some shifts in the regulatory enforcement environment that may touch accommodation obligations from a legal perspective. The laws haven't changed, but some of the enforcement priorities or some of the relative risks that surround these things may have shifted recently. Being resourceful. The second chance law is the law I mentioned. Indiana has a second chance law. Many states do. So keep that in mind and look that up as something that may be a good option. Be vigilant, especially if issues of bias or concerns about being willing to explore these issues and talk about them openly within the workplace, not necessarily about a specific employee, but about the approach to these issues within the workplace. And then also seek guidance. Work with your in-house counsel, work with your outside counsel, work with your compliance professionals, people who are tasked. A lot of you actually may be those people, right? You're the people tasked with making sure that an organization is compliant with these different laws. And with that, this is the very end of the presentation, and we've added some different links that might be helpful to you as you go through. And I think right now we're ready for questions. If we want to tackle a couple questions before we give Ryan some time to finish us off and conclude our work together today.
Awesome. Thanks so much, Shelley. Great
Awesome.
high level. I know that you could present for a lot longer, right? Multiple day workshops on this topic alone. So
Yeah.
very high level, but still, I think really helpful for our clients, and the content thus far has generated some questions. We've got 10, in fact.
Thanks.
So
Okay.
I'm going to just start with the
Let's do
top.
it.
I'm sure that I'm kind of multitasking here, so I may have missed some of what you said. You may have already implied or answered some of these, but I'm just going to go ahead and ask as they were presented to me. The first
Sounds
one,
good.
thankfully, is from Erin. Thank you all, by the way, for submitting your questions. Do appreciate it.
Yes.
Erin,
Yes.
she asked, does Title I of ADA apply to tribes and tribes businesses?
That is a fantastic question, and I know exactly the person that can answer that question, and it is not me. So I have not addressed that specific issue and question, but that is actually a much more complicated analysis because there is a specific treaty-based analysis that you have to make to determine which federal laws apply and to what extent. So I unfortunately can't provide an on-the-spot answer. It is something that I can find out the answer to fairly easily. If you wanted to reach out to me for additional feedback, I would be glad to do that. Like I said, I have
Awesome.
a colleague that could answer this off the top of his head. It's just not me.
Perfect. So Erin,
That's a
Shelley's gonna put
fantastic
her,
question.
yeah, she's going to put
Yeah.
her contact information up on the very last slide. Please reach out to Shelley directly to get that answer. Lucy
Yes.
asked for a pregnancy accommodation. Is the employee required to provide a doctor's note for the accommodation?
Ooh, good question. So that question actually implicates two different laws. It's the ADA, but it also is the Pregnant Workers Fairness Act. I will tell you, under ADA, there is a process that employers go to that can require a medical certification. The Pregnant Workers Fairness Act actually has a specific requirement that if the employer is aware of and knows the existence of the requirement for obligation, which in this case would be pregnancy, they are actually limited in what they're able to ask. So there are contexts in which it would be unlawful to require a medical certification for a pregnancy accommodation. But the answer to that is, what are the circumstances, what kind of accommodation is being requested, and whether we're looking at the Pregnant Workers Fairness Act or the ADA. That's a
Awesome.
great question.
Two good questions. Let's keep it
I
rolling.
know. This
Ask.
is fantastic.
What about jobs that this again? This is the third, so this is a little bit earlier in your presentation, Shelley. What about jobs that require heavy physical requirements such as construction, climbing ladders, heavy lifting, walking on rebar, climbing in confined spaces? Many people cannot do if they have certain disabilities.
Yeah, that's a good general question that relates to ADA accommodations in general. One of the requirements to be a qualified individual with a disability is that you are able to perform the essential functions of the job with or without a reasonable accommodation. So that's the standard, is if someone cannot perform those functions, or if they are they're not considered, or if they cannot perform the functions, and that can be a very fact-intensive inquiry, so it shouldn't be assumed that someone can't perform the functions, then that can be a basis to determine that they would not necessarily be a qualified individual under the Act. But you have to be very careful there, because a reasonable accommodation may take someone who otherwise couldn't have performed those functions or could perform them in a different manner and still perform the essential functions of the job. And then also for the Pregnant Workers Fairness Act, again, not the main focus of our discussion today, the Pregnant Worker Fairness Act does require that if someone temporarily can't perform the essential functions of a job due to pregnancy, there does need to be an analysis of whether a reasonable accommodation is available. There's a case involving a pregnant worker who was unable to lay on their stomach for the pendency of the pregnancy. They couldn't do that, and that was part of their job. And there was a suit filed with respect to not failing to make that accommodation.
Great. So the questions are continuing to pour in. I'm just going to stay it right now. We're not going to be able to answer them all during today's webinar. Perhaps, Shelley, you and I can touch base after. Maybe we could get a couple of them answered as it pertains to today's topic. Okay.
Yeah, absolutely.
So Leah asked, when a mental health or addiction issue creates an employee relations performance issue prior to a request for accommodation, how does that impact an employer's responsibility with the interactive process?
So as I understand it, there is some belief by the employer that there could be a mental health or substance use disorder accommodation needed, but it hasn't specifically been requested yet, is how I'm hearing that.
That's my understanding as well.
Okay, so it's based on what the employer knows or should know. And so even if there's no magic language, and even if an employee hasn't said, hey, I need an accommodation here, if the employer reasonably knows or should know that that employee could need an accommodation, that triggers the interactive process. So it, again, very, very fact specific. What information does the employer know at what stage in the process? But it can be that someone who has not yet formally requested an accommodation could still be entitled and also have a responsibility to participate in the interactive process. So that's a good thing to remember for that question, that the interactive process is two-sided. The employee has to participate and the employer has to participate. Again, great questions. All of these are great questions.
Love it. Anne asks, what about a test for drugs in a state where it is legal? However, per company policy, it is not in adherence. Do state legal drugs count under ADA like alcohol?
I'm not sure. So I think the question, it's legal to conduct the test generally, but you're saying that there's a policy not to do so. I'm not sure. Can you read that question again? I just want to make sure.
What about a test for drugs in a state where it is legal? However, per company policy, it's not an adherence. So policy prohibits its use, but it's medical marijuana, for example. Do state legal drugs count under ADA like alcohol?
Oh, okay. I see what you're saying. Marijuana itself is actually a perfect example. So for ADA's purposes, the definition of an illegal drug follows the federal standard for illegal drug. And right now, even though there are states that have implemented legalities surrounding medical marijuana, recreational use of marijuana, at the federal level, it's still pursuant to ADA, it's still considered a test for an illegal drug. If it is legal at the state level, one of the things that's really important, and I love this question because it's really important to understand what the state law says and reconcile state and federal law, because you can sometimes get a rub between state and federal law if there are employment-related protections provided to individuals for the use of marijuana, whereas the federal law still says that it is an illegal drug. So you just have to be careful to navigate both of those as you're going through.
Great questions. Love it.
And one more comment there. So there was supposed to be a descheduling or a de-escalation of the scheduling of marijuana earlier this year. That has not yet happened, and it actually has been delayed with the transition between the administration. So any of you who knew that was on the horizon and thought that there might be a change to the regulation of marijuana at the federal level, it looks like we're at least on pause for right now on that.
Okay. I think we might have time for maybe one more question. Again, the questions are just rolling in. So Shelley, I'll follow up with you, and any questions related to this topic, perhaps we can answer and get that sent out with the copy of the slide deck, perhaps.
Absolutely.
Let's go with, I hope I'm saying your name correctly, Saima. What happens when someone is hired who is already, say, working with a substance abuse professional, like a DO2 qualified, from another employer, or maybe they're currently in a rehab with a certain treatment provider, and now they're seeking future employment? How do ADA protections apply to them?
Oh, that's a great question. So I think the facts and circumstances of that application process and where they are in that process are going to be really important. But as it relates to, so let's assume someone is in a treatment program and is in recovery. The question becomes, or the appropriate question is, first of all, be careful about making medical inquiries throughout the process. Now, sometimes people are very upfront, and that actually can be part of the recovery process, is being very upfront and being very transparent. But keep in mind, the medical inquiries, you have to watch the timeline there in terms of whether you're pre-offer, post-offer, what kind of inquiries you're making. But if someone is in recovery and they're working through a particular functional program, now, if you are, some programs are formal programs, whether you're participating in a formal program is one thing, but if they're requesting, for example, a reasonable accommodation to attend meetings, that could be something that would still be a reasonable accommodation even at a new place of employment. If they can, and again, the question is, are they able to perform the essential functions of their job with or without a reasonable accommodation? And participating in a program that requires someone to attend periodic meetings may be a reasonable accommodation. That's going to depend on what the nature of the job is, what the attendance requirements are to keep things functioning for the employer. If you've got a 3-employee, well, that's a super small employer, but let's say you have a 15 employer place, but there's only one person that can do a particular job, that may be a different scenario as to whether that person can leave early or arrive late or things like that to attend meetings. But it's, so you just go through the interactive process to decide that.
Okay. Awesome. Well,
Awesome.
yeah, we've got 3 minutes left if we want to close at the top of the hour. I know that I personally could ask Shelley a lot of questions as a substance abuse professional and certified employee assistance professional. Perhaps a part 2, if you'd be up for that, Shelley.
I would love to, yes, because I do feel like this was a huge flyover, right? We just did a flyover of really, really interesting, deep topics. I would love to do that. So
yeah,
thank you.
awesome. So on that note, if we could go to the next slide. If you're interested, perhaps in diving deeper into this topic, bringing Shelley back, maybe more like a Q&A type format where it's just ask the expert. There's no slides, just fire questions away, and she answers them for us. Let us know if that's something of interest to you. Please complete the survey. It's completely anonymous. It's fast, and again, helps us to secure timely topics and high quality speakers like Shelley. Next, as promised, go ahead and look in the chat for your HRCI program code and your SHRM activity ID. Again, these will also be listed on your certificate of attendance, which will be emailed to all participants end of day next Monday, April 28th. ARCpoint Marketing is on it. They went ahead and posted those. That brings us to our final slide today. If you have additional questions for Shelley, something pops up later today, next week, you've heard it from her, you can reach out directly to her. And if she doesn't have the answer, it sounds like a team member is going to. So please reach out to her. Her email, her phone's up on the screen. And also, again, a link to this recording will be sent out with the PDF certificate, this PDF copy of the certificate, PDF copy of the slide deck. So you can also listen to this webinar again and get her information on the recording or the actual handout. To stay up to date on ARCpoint's Thrive webinar series and other announcements, I encourage all of you to follow ARCpoint Labs on LinkedIn. And if you're interested in learning more about ARCpoint's range of employer solutions that support worker well-being, check out the Employer Solutions page on ARCpoint's website, or simply reach out to your local ARCpoint Labs provider and schedule a free consultation. You can also sign up for a free consult by simply scanning that QR code, and then an ARCpoint rep will reach out to you. And lastly, for those who may be new to the ARCpoint brand, we offer a suite of services designed not only to enhance worker well-being and performance, but also to help prevent, identify, and manage issues affecting safety and performance, such as mental health issues, substance misuse issues. Any one of our locations across the U.S. would welcome a conversation about our employee assistance program, well-being solutions, our drug testing services, random program management, DOT physicals, background checks, staff and leadership training, and the list goes on. So if you have questions, reach out. We'd love to hear from you. And we are at the top of the hour. So on behalf of the entire ARCpoint team, a very special thank you once again to attorney Shelley Jackson. Thanks for being here. And thank you all for spending your time with us today. We hope to see you at next month's webinar, where we once again help you and your business thrive in 2025. See you then.
Thanks, everyone. Thank you, Ryan.